Good luck. Thank you, yes.
My Lords, we're at tab 8 of the authorities bundle, page 58.
Yep.
I think I had got down to the end of the master key paragraph.
Yes.
I'll read just a very short passage. I did not set out the relevant provisions of the 1983 Act as to whose that was the Value Added Tax Act. As to whose construction the parties are not in dispute, and may turn to the factual background, which is as follows. Reed's business, so far as material to this appeal, is the provision of nurses and thus their services to hospitals. But I use the term provision advisedly as a neutral expression, so as to beg no questions as to the nature or identity of the supplies made by Reed for the purpose of the Value Added Tax Act. Then, if we go to G, Dr. Laysock QC was counsel for the Customs and Excise. In his skeleton argument, he extracted the three following critical passages from the Tribunal's decision.
How much do you want us to read?
If you could just read those three passages,
Oh, I see.
then I think I would like to read the last from J onwards aloud.
Very well. Yes.
That was the finding of the VAT Tribunal which Dr. Laysock was trying to impugn. Now, Dr. Laysock invented three archetypes of contractual relationships involving three parties in order to submit that the Tribunal had fallen into an error through a mistaken classification of the contractual relationships which have to be considered in this case. They were: 1, where A is contractually obliged to provide services to B, but does so by means of the act of a third party, C. Now that's clearly the facts of main pay, it is clearly the facts of mercy. Sorry. You say something. This may be described as the vicarious performance situation. And that is what the commissioners were contending was the position in Reed. Now, 2 and 3 are not in point here. We look at them very briefly. 2, where C as agent for A enters into a contract obliging A to provide services to B. This is the agency situation. 3, where A acts no more than as an intermediary between C and B, introducing the two, so that C may enter into a contract by which he undertakes to provide services to B. This I call the intermediary situation. And that was being held by the Tribunal, and that finding was upheld on appeal, was the factual situation in Reed. Now, in the vicarious performance situation, Dr. Laysock submitted that the services factually performed by C, that's the third party, in this case that would be a nurse or a doctor, were, both as a matter of contract and the law of VAT, supplied by A to B. In this case, say main pay by main pay to either directed to a hospital or to an agency. So also in the agency situation. In the intermediary situation, the services factually given by B to C are also legally supplied by C. A makes an entirely different supply to B, constituted by the services of making the introduction between C and B. And Dr. Laysock's case was that the Tribunal had erroneously classified the relationships. I'm happy to say I needn't take your lordships into the nitty-gritty of the actual facts and the decision. The important point to note is that what was meant by supply of staff, in that case, was that where you have the intermediary situation, the mere introduction of staff. It didn't mean seconding staff.
Can I understand the first example that you say is present case and main pay. Can you break that down for us? A is contractually obliged to provide services to B. What do you say that entails in this case?
Well, on the facts, A agrees to second the services of a given consultant to B.
Yes.
And that would be the contract between the two of them. Of course, the services will actually be provided by the consultant. Who is
Yes, but not to B.
But not...
The contractual obligation of A is to provide staff to B.
Yes.
And it doesn't do that by means of the acts of a third party. Providing the third party is performance of the contract.
Well, it's all a question of what's meant by providing the third party. A says we hereby agree that the services of that certain services will be performed for the benefit of you, the third party, and they will be actually performed by C.
No, but that's not the agreement, is it? The agreement isn't to provide services. The contract is to provide the member of staff who will then do whatever B wants them to do.
Well, of course, it turns on that would turn on the terms of the secondment, which will normally be subject to a schedule.
Well, except that the decision of Mr. Justice Laws was precisely the opposite. He said the contracts were not determinative. It was a question of fact. The question of fact had been decided by the tribunal. It wasn't Waynesbury unreasonable. End of.
That was his ratio, yes. But I'm not citing the case as authority for anything. I'm citing it to show what was the distinction that was made between the supply of staff and the supply of services in this case. The supply of staff means introducing the staff. It does not mean entering into a secondment. You see, if you look back to the head note at D to E on page 57, Reed appealed, contending that while its supplies to clients went beyond mere introduction, it had acted as a recruiting agency, supplying staff, and not the staff services, and the nurses had supplied their services direct to the client. So what was meant by a supply of staff was finding staff who would work for the hospitals. The crucial thing is that Reed didn't argue. It was the commissioners that argued. And neither the tribunal nor Mr. Justice Laws found that Reed was supplying staff in the sense that Main Pay and Mercy were supplying staff, i.e. they were seconding their services. They were merely effecting an introduction, for which they were paid a fee. That's the crucial point about the case.
Yeah, well, that's the point you've made very fully before taking us to it.
Thank you, Lord. If I can just take you one very small passage at page 63, between D and E, it's the beginning of the paragraph. Mr. Justice Laws said, Dr. Laysock can only succeed if on its true construction taken as a whole, the contract with Barking, that was one particular place, and other contracts, produces the inevitable result, this was Wensby unreasonable of course, that the supplies of nursing care, that is what nursing services means, which the hospital undoubtedly receive, are made to them not by the nurses, but by Reed. Now, Mr. Justice Laws upheld the tribunal decision that, certainly for VAT purposes, having considered the contractual documentation and the whole background, Reed did not enter into a contract with the hospitals whereby it supplied the nurses or it supplied their services. What is instructive there is that Mr. Justice Laws makes no distinction between the two.
Seems to me I have a real problem with the concepts here. It seems to me that a hospital provides nursing services. It doesn't receive nursing services.
Well, it can receive services too. No? Of course it provides nursing services, but it receives the services of nurses. A nurse, let's take out of the picture the case where the nurse is an employee of the hospital, simply because for VAT purposes that's disregarded. But you might well have a freelance nurse. With the gig economy, that's very common nowadays. If the nurse will enter into a contract with the hospital to provide his or her services, will that's clearly, and will get paid for it. That's clearly a supply of something. And my submission, it's fairly described as a supply of nursing services. The hospital is then going to use them to make its own supply to its own customers.
I've got a different problem, which is you seem to be suggesting that this case turns upon it being a mere introduction case. Now, if that is your submission, that seems to me to be falsified by what's said in the last paragraph page.
Of which page? 594, my lord?
Yes, where what Mr. Justice Laws says is that the contractual documents are actually pretty clear. And he says at G, the obligations they place on Reed shoulders are clear. They're to make available the nurses, and therefore, in common sense, the services that the nurses provide to the hospitals. Doesn't follow that Reed, as opposed to the nurses themselves, provide nursing care. Reed also undertake a raft of associated functions, which is common ground, travel beyond the business of mere introduction. Mr. Milne intervened helpfully in the course of Dr. Lassock's submissions to make it clear his case was not merely that his clients introduced the services, they carried out ongoing services as well. So this wasn't a case of mere introduction. On Reed's own case, there were further services being provided.
That's right, my lord, but the further services were not the provision, that is, not to the secondment of the nurses. The further services were of an administrative nature. I think that's mentioned in the head note. For example, a major service would be that under income tax and national insurance legislation, in a situation like this, where the nurses, as held by the case, were the employees of the hospital, normally you would expect that the hospital would have to operate pay-as-you-earn and account for income tax and national insurance contributions on the nurse's income. However, there is a special provision in the Taxes Act which says that when the introduction is via an agency, such as Reed, the obligation is placed on the agency. Now that operating the payroll, as it were, would have been a very important administrative function. And this was part of, and it would have somehow rather needed to be paid for that. But, so while what your lordship says is correct, it wasn't just affecting the introduction. This doesn't affect the basic point that this was not a distinction between, this was not a case where Reed was undoubtedly providing, was the employer, let's put it clearly, was the employer of the nurses, and was, to use a neutral term, making their services available to the hospital.
Well, let's then look at what's said at page 64, page 595 in the original report.
64 sorry, I didn't quite catch.
At page 64, at between H and J, right near the foot of the page, where Mr. Justice Laws says, I would incline to accept Mr. Milne's argument that taken as a whole, the documents, that's the contractual documents, indicate that Reed was supplying nurses, not nursing services. He then goes on to say, however, for the reasons I've given, the case is not resolved in Mr. Milne's favour any more than in Dr. Lassock's, simply upon the construction of other contracts. They don't put beyond question the nature of the supplies made by Reed, nor was it their function to do so. And that then leads on to the conclusion with which I started before the short adjournment, which is that the tribunal had found as a fact that what Reed supplied was nurses, not the nursing services. And that wasn't reasonably unreasonable, and therefore the appeal was dismissed.
But what was meant by supplying nurses? In the context of this appeal, supplying nurses didn't involve saying, here is a nurse who's looking to getting £1,000. We will, as a matter of law, contract to provide that nurse for 1,100 or whatever.
Well, undoubtedly the contractual arrangements in the present case, as in main pay, are different. But what's the relevance of that? Because the point that's made here and picked up in main pay is that there's a distinction between a supply of staff, in the Reed case, the nurses, and a supply of medical services. That distinction emerges clearly, does it not, from the concluding paragraph of Lord Justice Law's judgment, and that's what's picked up by Lady Justice Whipple in main pay.
My Lord, that's right, but what I'm submitting is that the distinction is not the same distinction as was thought to be relevant in main pay, and which Lady Justice Whipple thought was the distinction in Reed personnel. In main pay, just as in this case, it is absolutely clear that main pay Mercy was contracting, was the employer of, say, the nurses, and was contracting to provide, if you like, them, if you like, their services. Just let's leave whether the two can be equated. But on that basis, it meant that the entire consideration paid by the hospital would have been the value for the supply made by Reed. And the whole point in Reed was that Reed claimed that yes, it made a supply. It didn't claim it was exempt, it was quite the other way around. It made a taxable supply. But the only element that was taken into account in calculating the value of that supply was its commission. It wasn't the entire amount which was paid by the hospital, both for Reed's commission and for the use of the nurse's services. You see, whereas in main pay, you've got a situation where main pay, let's forget about any intermediary, just simplifying the situation, but main pay contracts with the hospital that it will provide the nurses, provide their services, we leave that blank for the moment, but will do so for a gross consideration. Main pay is the employer, and out of that gross consideration, it will pay employment and national, it will pay the employees' emoluments, national insurance contributions. But the crucial distinction, if that had been the case in Reed personnel, Reed would not have been arguing what customs and excise, what it was arguing. because it would have had a whopping output tax, not only on its commission element, but on the entire amount paid by the hospital for the services of the staff.
But do we know from the report of the case what output tax, if any, Reed was paying? Because the case is all about the input tax. I mean, yeah, I may have missed it, but I haven't seen any reference at all to what, if any, output tax was being paid.
Well, it may only be in the, we may have to go in the nitty-gritty on this, but can I just say a priori, if, say, the hospital's paying 1,050, 1,000 in effect goes to the nurse, including their income tax, etc. 50 goes to the agency. If Reed had been making a supply of staff in the main pay sense to the hospital, then it would have snatched Custom and Excise hand off. And Custom and Excise said, this isn't taxable, this is exempt. We don't want value added tax on the whole 1,050. There would have been a slight drawback in that Reed wouldn't have been able to deduct any input tax, but that would have been far less than any output tax on the basis that the 1,050 was a taxable supply as opposed to an exempt one. So this litigation only makes sense on the basis, and I will look and see if there's something in this, it will be there somewhere. It may only be in the tribunal report below that it comes in detail. Well, I'm sorry. Maybe that's something I could look at overnight and see if I can find there's evidence within
What
this.
about that's where your junior can be looking, surely? Your junior can be looking, surely.
Possibly, although my junior doesn't claim to be a tax expert and will probably have access to the tribunal reports. But we'll,
Oh, I see. So I thought you meant looking in the report. No, okay.
yes, that was the. There will be a tribunal, or probably a tribunal report reported somewhere, which we'll probably have access to in our chambers. Now, I'll just see if that's made more clear. But the dispute makes sense only on the basis that, well, it does that the only supply, the reason Reed wanted to argue it was simply being paid for the introduction was because that would have been a relatively small amount, say the 50, rather than the 1,050. It would have been prepared to pay output tax on that. But then, as a corollary, it would have been able to recover input tax. And it could be one of these curious situations where the input tax was greater than the output tax. We don't quite know. There must have been some inverness in this particular case. But
I think there's you've got a single point to make about Reed. You've made it more than once and very clearly. We need to move on, don't we?
thank you, my lord. If we can now at last look at, and let's take some time, look at main pay in the Court of Appeal, which is Division 7 of the Authority of London. I think I can pass over 29 to 31 of my skeleton. They've already been covered. And 32.
Sorry, I'm confused. I thought you were taking us to main pay, but you're taking us to your skeleton.
I'm sorry?
It's not clear to me whether you are taking us to your skeleton or whether you're taking us to main pay. You said we'll go to main pay, and then you said skeleton 27 to 31 were already covered, so I wasn't quite clear what I was supposed to be
Well,
looking
yes, if you're, I'm trying to follow the skeleton through as near as possible, Lord. We are going to main pay. Perhaps I can pick up the question your Lordship raised this morning, to which I gave an incomplete answer. I had said that the argument, what I should have said, but perhaps I didn't, was the argument of the taxpayer throughout was based on there being a distinction, a different distinction from that in Reed, between a supply of staff and a supply of services. And that was maintained in the Court of Appeal, and it had been accepted below that this depended, whether the supply was one of staff or services, depended on whether or not control of the appropriate degree was retained. Now, by the time the case comes to the Court of Appeal, there is leading counsel brought in for the revenue. And he, if I can take you to page 45, at the bottom, paragraph 47. He is admittedly backing away from what had been common ground before. Mr. Singh, who did not appear below, with Miss Taylor, who did, argued for HMRC that the sole issue before the court was whether main pay services came with a medical exemption. If they did, the appeal succeeded. If they did not, then the appeal failed. And it was not necessary to define main pay services, whether as a supply of staff or anything else, because by operation of Section 4 of the Value Added Tax Act, those services would be taxed at the standard rate. On that footing, much of the first-tier tribunals and the upper-tier tribunals' analysis of what amounted to a supply of staff was, strictly speaking, unnecessary. And main pay's arguments that this was not taxable supply of staff missed the mark. Now, while the taxpayer is still arguing on the supply of staff, these supply of services distinction, obviously HMRC has recoiled from that, but it's interesting that those arguments are not taken into account. So at page 56, paragraph 90, Lady Justice Whipple says it's not necessary to deal with the different or additional grounds relied on by HMRC in their respondent's notice. And she says, somewhat perhaps not quite accurately, broadly, they're all facets of HMRC's overarching contention, accepted by the first-tier tribunal, the upper tribunal, that main pay was making taxable supplies of staff, not exempt supplies of medical services. Now, Mr. Justice Richards had criticised our argument had characterised our argument as being one which was put forward on behalf of the taxpayer in main pay. Now, perhaps I can take what is said in the skeleton as read and pick up the crucial passage which starts on page 46. It's paragraph 51 onwards, and it's a passage headed supply of staff or supply of services. Supply of staff or services.
Well, as you won't be surprised to hear that we've read this more than once. I don't think you need to advise us to read the whole thing again, but obviously you may want to pick up particular points in it.
Well, can I go through maybe picking up the points I'm making in my skeleton?
Yes.
We say at paragraph 36 of our skeleton. I know that's. This is at paragraph 38 of the skeleton. And we're looking at paragraph 51 of the judgment. Where Lady Justice Whipple says starting at 8, but in any event I'm quite satisfied that there's nothing wrong conceptually in approaching the issue in the way the first tier tribunal did, by asking whether this was a supply of staff or a supply of medical services. The two analyses are mutually exclusive. If there is a supply of staff, that necessarily means the supplies are taxable and not exempt.
Yes.
As we say in our skeleton, the last three sentences are mysterious, and the last sentence is a complete non sequitur. Her Ladyship isn't agreeing with the upper tribunal, or it appears with counsel for HMRC. The upper tribunal had considered the control test as irrelevant, and I refer to the, perhaps I don't refer in the skeleton, it's paragraphs 92 and 93 of the decision, and applied it only because that was the way the appeal was argued before it. That's paragraph 129 of the decision. Yet Lady Justice Whipple considered it self-evident that if there's a supply of staff, then that must mean the supply cannot be exempt, because it cannot be a supply of medical services. And our comment is this is an unreasoned assumption which can't begin to be dignified with the description of consideration of the question. It is a mere assumption. We say at paragraph 40 of the skeleton, any persuasive force the assumption might otherwise have had, quite apart from any question of whether it could create binding precedent, is in any event completely undermined. The whole passage of paragraphs 51 to 57 was hopelessly confused, as it ran together the two different types of distinction, which I have been at pains to point out in my skeleton, for the March 15th hearing. The first is a distinction made in Reed between A, supplying staff in the sense of effecting an introduction, and B, supplying staff by seconding their services. That is, in our submission, a sound distinction. But the second distinction, which was the one relied on by the Court of Appeal in May, is a supposed distinction, the one which Lady Justice Whipple regarded as self-evident, that in a case where staff are supplied by being seconded, which is undoubtedly the case with both May and
If you'll just be reading out your skeleton.
Sorry, what?
You're just reading out your skeleton here.
Indeed.
Yeah, well, okay.
Well, actually, I'm reading stuff which wasn't in the skeleton at the moment.
Are you?
It's the end of I'm making additions to paragraph 40.
Yes, actually, keep going. Well, I thought you were just reading paragraphs 41 and 42, or anyway, paraphrasing them.
Well, I'm, as it were, expanding. A skeleton is a skeleton, and the speech is slightly.
Okay.
Now, it's clear that she had in mind the distinction of supply of staff, the supply of services, which was relevant in Reed, and Adecco, which was a case of decision of this court. So if you look at 53 of Lady Justice Whipple's judgment, she says a distinction between the supply of staff on the one hand and supply of the services of those staff on the other is reflected in case law in accordance with ordinary principles of VAT. As examples, she mentions Reed. Now that is, as pointed out, it's a completely different distinction. She has confused the distinction in Reed with the distinction the taxpayer in particular was relying on in main pay. At 54, she says, two cases discussed at some length by the First Tier Tribunal and the Upper Tribunal raise similar issues. Adecco involved a dispute about the VAT treatment of an employment bureau, which supplied clients with temporary staff who were not employed by it except for certain regulatory purposes. It was very similar to Reed in that the taxpayer argued that VAT was due only on the part of its overall fee charge, which was consideration for the introduction, if you like, the commission, and not the whole amount. Whereas HMRC argued that VAT was due on the total sum paid by the client to the bureau. That was a different argument, of course, from Reed. It would be helpful to look at Adecco. That's at the Authorities Bundle 10. I'm sorry that we're also in the middle of main pay. At page 72. And I need to take you principally to the headnet, which is quite long. Could I possibly ask you to read that?
Yes. Yes.
So in that case, Adecco, the Bureau, was held on the true construction of the contracts, etc., in the circumstances, to have employed the workers and to have supplied the workers to its clients. This is therefore a distinction of the read type. It is again not a distinction of the main pay type. So Deco's argument has been, oh no, we don't do that, we simply get paid our commission for effecting an introduction, etc. Of course, I admit there was no question of any exemption in Deco, but still it was a different test, a different distinction that was being employed. Just before we leave it, it's instructive to look at, on page 74 of the bundle, paragraph 3 of the judgments. At para 2, Adecco had put forward the argument it was merely introducing candidates to clients. Whereas at paragraph 3, you see HMRC's position. HMRC, on the other hand, denied that any such distinction falls to be made. According to HMRC, Adecco is obliged to account for VAT on everything that is paid by a client. The temp services, HMRC say, are supplied to clients by Adecco. And for what it is worth in that case, HMRC weren't saying the temps are being supplied because they're being seconded. They were saying their services are being supplied. And that was only when? 2018.
That wasn't a relevant distinction in that case.
It wasn't, you're quite right, my lord, so I said for what it's worth. It's, and your lordship's observation is correct. There was no question, certainly of the health exemption or any other exemption that would have turned on that. So, what I would say about Adecco is that although it's relied on by Lady Justice Whipple in main pay, there is nothing in it to support a distinction between a supply of staff by taking part in the chain of supply while controlling them, on the one hand, and on the other hand, a supply of staff by taking part in the chain of supply without controlling them. So, as we submit at paragraph 42 of the skeleton, the distinction Lady Justice Whipple had in mind was the wrong distinction. The distinction in Reed and Adecco form no part of the argument of main pay or indeed of HMRC in main pay. Similarly, it is not an issue in the present case. And if Lady Justice Whipple had kept in mind the correct distinction, she would have realised that she was indeed asking whether the control test was satisfied. And unfortunately, I have to say this, she in fact got the wrong end of the stick and mistook what the argument was all about. And that is the major plank of our argument on manifest error. Returning to the main pay judgment, we've made comments on what she said at paragraph 52 as to why the tribunals had approached the issue in the way they had. I won't enlarge on those now. So we say that paragraph 53 and 54 I think I've considered. Now, paragraphs 55 and 56, she makes a fresh independent point. This is based on a decision of the European Court of Justice in Horizon College. which she thinks supports the distinction between a supply of staff and a supply of services. And I needn't labour this, it's pointed out in paragraph 51 of our skeleton, that if you look at the education exemption, it was in very different terms. I can take you to that because we happen to have it in the bundle if your lordships would like to see it.
Speaking of myself, not, because you've set it out in the skeleton.
Well, I'll just say that if you did, it's in the authorities bundle, page 24, the right-hand column, and it is letter I, not number, little Roman 1. And you'll see it's in very different terms from the health exemption. So, her conclusion, 57, these cases make clear that there is a distinction between supplies of staff on the one hand and supplies of services comprising what the staff actually do on the other. With respect, they don't. And two of them, the two most important, Reeds and Adegbuyi, are concerned with a completely different distinction from the one...
Yeah, well, you have made that point more than once.
I'm sorry, my lord.
But the tricky point, the point where the argument, suppose all of that is right, at 53 you say, hence the passage contains nothing more than a mere assumption. It's hard to describe as an assumption. It's a decision, clearly a considered decision, which has been developed over several paragraphs. What you're saying, surely, can only be that it's wrong, and really wrong. Your manifest error point. You can't say it's an assumption in a Kadim sense.
I see the force of that, my lord, and clearly the argument that this is something that is so fundamentally wrong, so palpably wrong, that it comes within per incuriam rule is a much stronger argument than this is something which is a mere assumption.
Yeah, okay. We see how you put it. Where do we go now?
We now go to something your lordship raised earlier today. It's page 54 of main pay. A section headed Commercial and Economic Reality. And in particular, paragraph 82, which your lordship had already mentioned this morning. I think it might be helpful in the first instance if I asked the court to read paragraphs 79 to 83.
Well, pretty well all our pre-reading has been consisted of reading main pay and what's said about it. I don't really think we need to sit here and read this again.
Very well, my
You
lord.
should, of course, draw your attention to our attention to the particular points you want to make about it.
So, 79 is important because this introduces this section. Main pay argued that it had control over the consultant in a number of different ways. I've already dealt with this argument in the FTT that it retained control over clinical decision making, an argument that the FTT rejected by looking instead at the framework of control over the consultant, finding that was operated by the NHS trusts. 80, this is important. Other variants of main pay's case on control resurfaced during the course of the argument in this court. I shall deal with them briefly. So her ladyships describe all of these as variants of main pay's case on control, not freestanding arguments independent of it. The first, we needn't be concerned with, it was clearly a bad point. While the second, at paragraph 81, was also a bad point, clearly a bad point. These are arguments which obviously weren't in the skeleton, they were developed during the course of argument. We need to look at it because it's referred to in 82. Secondly, main pay argued that it was in control of the consultant's clinical decision-making by virtue of the employment relationship, relying on Article 10 of the Principal VAT Directive. That's not before you, but Article 10 of the Principal VAT Directive says that an employee does not make a supply to their employer by virtue of being paid for their employment. That's paraphrasing, but that's what it boils down to. This was rejected by the first-tier tribunal and by the upper tribunal. I agree with the upper tribunal that the effect of Article 10 is to remove the activities of employees from the scope of tax, and that it does not operate to confer on the employer all the activities of the employee, nor does it necessarily make the employee's activities part of the employee's supplies for VAT purposes. That decision was clearly correct. But then we come to paragraph 82, which is to some extent enigmatic. Part of the problem here is it's not clear exactly what argument had developed during the course of the hearing, except that it is said to be a variant of main pay's case on control. And I've stressed several times, we say control is irrelevant. So thirdly, and for the first time in this court, main pay submitted that main pay's services were the same as and were constituted by the services provided by the consultants. Now, this is, of course, if you look at the submission, that is indeed our submission. That in providing a consultant to carry out surgical operations, main pay is not, or Mercy is not simply providing staff, it's providing the service provided by the consultant. Now, what her ladyship says, which is difficult to understand, this argument runs close to the Article 10 argument, which I've rejected in the preceding paragraph. It's not quite clear how it does, because our argument has nothing to do with Article 10. It's quite freestanding. She said it was advanced as part of the argument based on Kugler, paragraph 27, which I've also rejected, and which we agree her ladyship was right to do. But then the interesting bit is, but in any event, this argument fails in its own right. As a matter of principle, it wrongly conflates a supply of staff with the supply of services provided by those staff. But these are conceptually distinct types of supply, see paragraphs 51 to 57 above. So that argument doesn't involve independent reasoning. It takes us back to 51 to 57 above. And if, as I have submitted, they are fundamentally flawed, then it has no validity as an independent argument.
Well, exactly, but this, from the point of view of what you're running, this doesn't add anything.
It doesn't add anything.
The reasoning is just the same as 51, 57. It's either right or wrong, manifestly right or manifestly wrong. Indeed. This para is important only in that it shows its ratio and deflates any argument, which it turns out you weren't taking anyway, that para 57 isn't ratio. Whether it's ratio when it appears at 57, it's certainly ratio when it's adopted here. So
it also goes to the question of mere assumption, doesn't it? Because doesn't this demonstrate that what she said at 51 to 52 isn't mere assumption? On the contrary, it's reasoning which she's positively relying upon to reject an argument advanced by the appellant.
Well, certainly, my lord, the fact she takes several paragraphs to make the point does support that, and so at that point we have to rely on it being manifestly wrong.
Yeah.
So, we've made a lot more progress than I was expecting. I think I can just summarise on precedent. Oh, sorry. There were certain matters that I said I would deal with. Could I just check? I don't think I may have dealt with all of these expressly. If I could just have a little check.
By all
Go
means.
through and deal with those points. There is one. I was asked whether it was possible for someone who was not a medical practitioner to take advantage of the medical exemption. I mentioned there was the decision of the European Court of Justice in Kugler.
Mm-hmm.
We now have copies of that.
Yes. I mean, no, they've already been handed up.
If I could, there's a lot of it, and unfortunately there's no head note, but if I could just take you very briefly to the crucial point. I don't think this is in dispute between the learned friend and myself. Paragraph 12 on page 6875 is the facts and the main proceedings. And we are told that Kugler is a limited liability company and that it provides medical care, of course, not directly, but through medical practitioners. And if one goes to page 6880, the question which had been put to the European Court of Justice was, can the exemption be relied upon by a person who is not a medical practitioner? It was in terms of the 6th directive, which has been consolidated into the current principal VAT directive, but there was no difference of meaning, expression. And at para 31, the court gives the answer. The answer to the first question was therefore the exemption envisaged is not dependent on the legal form of the taxable person supplying the medical or paramedical services referred to in that provision.
I may have misunderstood what the point was that you were being asked. I'm not anyway sure how important it is, but I thought the point being asked was whether the actual services could be that of a non-medical professional. This is a different point. This is about the distinction between the company and the supplier, isn't it? Or have I misunderstood?
Quite honest, I can't altogether. Excuse me a moment, I'll just open up the computer which has gone to sleep.
Well, it goes to the breadth of the exemption provided in what is now Article 1321C of the Principal Directive, which one might construe as being limited to services provided by medical practitioners themselves. But what this makes clear is that the legal form is immaterial, and that you can have a company that employs doctors and thereby provides services.
Yes, that's what the more elegantly put how it's.
I'm very
It's
grateful.
not, I think, the point that was being put to you, is it? But maybe. Anyway, thank you.
The only other very minor point, which has not been dealt with, it won't take a moment. Your Lordship, the Vice President, said on the question, what is an issue and what is an argument?
Yes.
And you mentioned judicial policy was important.
Yes.
There's not much to be said about this, except I would submit that if a decision is patently bad, is it really a good idea that it should continue to have binding authority? Is it not better that the court should say, well, actually, this decision is so bad, I mean, obviously it needs to be an extreme case that it needs not to be simply the present court disagreeing with the previous court, that we should really decline to follow it.
Yeah, so in other words, as Baroness Hale put it in, I think it was in Virgin and Zodiac, which is a patent case, finality is good, but justice is better.
That's so well put. I think
it's not me, it's Baroness Hale.
Even so, but I think your lordship probably has greater acquaintance with IP law than I do. It's very well put indeed, yes.
I can't remember the context in which that was said, though it's a very good phrase, of course. But one obvious context is it's said in the Supreme Court, which can always...
Yes.
Well, yes.
Complete finality, the position's a little bit different.
Well,
down the ladder.
I appreciate that, but I'm offering, as it were, I'm offering your lordships a peg on which to, as it were, an opportunity. If of course you're so minded, and if you agree that this decision is really so badly wrong, especially on paragraphs 51 onwards, that it really ought to be sorted out at this level, rather than having to go to, possibly, if one can have it to go to the Supreme Court. That would be a method of doing it. And you could, of course, make it very clear that this was not a whole root and branch upheaval of the law-binding precedent, but making another little exception for special cases.
Thank you. By the way, yes, I have remembered what the context was in Zodiac. It was the context was effectively Henderson abuse. Henderson and Henderson abuse. Doesn't matter. It's a good phrase, whatever. Yes. We'll rise for a moment or two and just review where we are. But I'm right in saying, therefore, that by one route or another, you have in fact both addressed the argument that you are not bound by main pay, or you addressed the argument that you are bound by main pay, or we are bound by main pay, but you have also, inevitably because of your Morel argument, said why there is an arguable point if we get over that.
I think that's right, my lord.
Yes.
Of course, I
But
haven't.
you haven't obviously addressed ground 3, I appreciate that.
And I haven't set out things that in the skeleton which are there, which I'm sure you'll have read, which didn't.
No, well, of course, as you...
But basically, yes, I have covered all that.
Thank you very much.
Court rise if able.
Well, we don't have the right full bottom please. That's the ones that come down over your shoulder. Because when people, Mr. Ware, noses are going to think they shave all their hair off. Yes, that's good help. Very sure.
rise if able.
Yes, Mr. Baldry. You'll have seen the way the argument has gone. The issues are, to some extent, narrowed, or at least brought into sharper focus, though in one respect, you may say that one of them was a point you weren't expecting. But if you can focus on those points, we've read your skeleton argument. I imagine you can do so quite economically, but over to you.
My Lord, yes. As to the approach that we say the court should be taking to this question, we've set that out in our skeleton. The starting point is to identify what is the proposition of law that main pay decided. And we say that main pay is authority for the proposition of law that if a supply in question is a supply of staff, can be characterised as a supply of staff, then that necessarily means that it's taxable because the supply cannot be described as any of the types of services which fall within the statutory exemptions. So that's the proposition of law which main pay decides, and we say that is part of the ratio of main pay because it was a proposition of law that was considered by the court expressly as a relevant proposition which it needed to decide in order to determine its decision. So the proposition of law we are concerned with is part of the ratio of main pay, and the question is then, can it be disregarded? Can that proposition of law be disregarded? Can the decision in the ratio of main pay be disregarded? And my learned friend had, as he said, two strings to his bow on that. One was the assumption argument that main pay had proceeded on this erroneous assumption that there was this there was a unanimity between domestic law and EU law, whereas his argument is that there in fact is a wider exemption available under UK law, which the Court of Appeal in main pay assumed was not there. But when it came to it, in my learned friend's submissions on identifying what the incompatibility, relevant incompatibility was, my learned friend did not make progress in establishing that there was any incompatibility between the domestic provisions and EU law. And our position is there is no incompatibility, there is no mismatch. The one thing I would like to clarify on that is just the relationship between the provisions of EU law and the provisions of domestic law, just to make clear how they operate. So if we go to the authorities bundle, Article 132 is at tab 5. Page 24 of the bundle. It has the two categories we've looked at. 132 1B, hospital and medical care and closely related activities, and C is the provision of medical care in the exercise of the medical and paramedical professions. And the broad distinction between those two, which has been recognised in the cases, and there's a summary of the EU law cases in the upper tribunal decision in main pay. B is broadly dealing with all the activities that take place within hospitals. That's the sort of governing nexus of B, whereas C is dealing with the provision of medical care by doctors and dentists, wherever, outside hospitals and out in the world. And those two provisions are reflected in the domestic law separately. If one goes to item 1 of group 7 on page 9, we see item 1, the supply of services consisting of the medical care by a person registered or enrolled in the following. That is the way that the United Kingdom has implemented 1321C, so the provision of medical care and the exercise of medical and paramedical professions, and that there is no incompatibility there. And 132B, hospital and medical care, is that the language is slightly different because the directive talks about hospital and medical care, whereas item 4 on page 11 says the provision of care or medical treatment in hospitals. It's the same thing. So the domestic provisions in the Article 132 are not incompatible. Had there been any incompatibility, one would have expected the Commission to have taken infraction proceedings against the United Kingdom when we were in the EU, as they did in respect of other aspects of the domestic exempting provisions. There was a time when the United Kingdom granted exemption for supplies of goods, separate supplies of goods, like glasses supplied by opticians, but that was infracted against by the Commission, and the United Kingdom had to amend its legislation. But otherwise, the domestic provisions implement the EU directive as usual, and the court is under its ordinary duty to interpret the domestic provisions under the mar-leasing principle insofar as possible, so as to accord with the European provisions, which is why in cases like main pay and all the other VAT cases, there is constant reference to the underlying directive, the cases of the Court of Justice on the directive as a means of construction, but ultimately what the court is always doing is construing the domestic legislation. So that's what the Court of Appeal has done in the present case. It is considered the scope of item 1, and in particular it considered the question of whether services of an umbrella company, such as main pay, could fall within the scope of that exemption. And as the upper tribunal was correct to say that as a matter of strict analysis, the only question is, do these services before us fall within the scope of the exemption? Are the services provided by main pay medical services? And once you've decided that, you don't strictly need to categorise them as being a supply of staff or anything else, because anything done for consideration that's not...
When you say the upper tribunal, you mean Mr. Justice Richards, do you?
I mean the upper tribunal in main pay.
Oh, I'm sorry,
That was part of the progression of the argument.
Yes, sorry.
Perhaps it would be helpful to have a look at...
I just thought it was a slip of the tongue by you, but it wasn't. It was just, I misunderstood what you were referring to.
Yes, it helps to explain how the arguments developed before the Court of Appeal in main pay. The focus of the case throughout was on this distinction between a supply of services falling within the scope of the exemption or a supply of staff. And the reason why, as Lady Justice Whittle explains, the reason why that was relevant to all the arguments in the tribunals below was that one started off with the revenues decision and assessment in the main pay case was that
this was to be regarded as a supply of staff rather than as a supply of medical services. And as the underlying decision under appeal was in those terms, that's framed the first-tier tribunal's approach to it. And as Lady Justice Whipple says, there's nothing conceptually wrong with that. Indeed, I think we saw in the Horizon case, the Advocate General also drew the same distinction. So, as a matter of strict analysis, the only question with VAT and umbrella companies is whether the services provided by the umbrella company of providing the staff fall within the scope of the exemption. And the only nuance that one has with that my Lord said, well, you've got to ask what was the consideration for? What was the person paying the consideration getting from it? And one has to bear in mind that Mercy's customers, as MainPay's customers, Mercy's customers are the recruitment agency. Mercy is seconding its staff to a recruitment agency, who in turn seconds the staff on to NHS trusts. So that's a similar model to MainPay. So the question is, how does Mercy and MainPay perform that contract? Well, by providing the staff. So that was the underlying question. As a strict matter of analysis, one doesn't have to define what MainPay services are or Mercy's services are. If they don't fall within the scope of the exemption because they're not medical services, then it doesn't matter what they are actually described as, because as the general rule of that, anything that is done for consideration by a taxable person is a supply of services. And Lady Justice Whipple went through that analysis in order to explain why this distinction that was drawn by the tribunals below remained relevant. If conceptually you can describe the supply that you're looking at as a supply of staff, if it looks like a supply of staff rather than of the services that the staff will actually carry out in their jobs when they're seconded to somebody else, then they are mutually exclusive. The supply of the staff is a different thing that someone does for consideration than the supply of medical services. So we have the distinction between a case like Kugler that you were shown, where the German company provided an outsourced patient care service and used individual doctors to carry that out. Well, that company came within the scope of the direction. But I think the difference between our case and the UK and Germany was that Germany did not have the equivalent of Note 2 in the group setting.
Equivalent of
Note 2, which is
yes,
the provision I showed you, where Note 2 makes it clear that the UK legislation was always compatible.
Do you accept that medical services can be provided to the hospital?
Yes, I would accept that. In that, if a nurse, a self-employed nurse, entered into a contract of services, self-employed nurse turns up at the hospital and is paid, then that could be exempt. I mean, the basic model we have is that the NHS will have its employees whose services are outside the scope of VAT just because they're employees. If in private hospitals, the doctors and the consultants will usually make a charge direct to the patient. In which case,
Yeah, that does slightly fudge the position then, doesn't it? Because if if a doctor or nurse can provide medical services to the hospital, then why isn't somebody who arranges for them to do so, providing such medical services?
In each case, you've got to look at what's the nature of the service that's really being provided. So, and is the person that is providing the employee doing more than just providing staff? And that's why the cases have looked at the concept of control. Not a defining concept, but it's not irrelevant to take into account that who is actually what is an umbrella company actually doing. So if you have a company like Mercy that has 1,000 employees, it may be some of them work in security, some of them work in medical services. Is that company doing everything that the
Well, what you say, they're not even
individuals
supplying
have
them
to
to the
do?
hospital, though, they're supplying them to the recruitment agency.
Yeah, in the present case, they are supplying them to a recruitment agency. But if they did supply them directly to an NHS trust, my answer would be the same. A secondment is not, I would say, is not the same as the sort of vicarious performance situation that was considered in the Reed case. Reed case established the basic proposition that the nurses were provided to the NHS trusts. Reed got its commission for it. Adecco then changes that somewhat, the analysis, because it confirms that if a worker is provided on terms that are global terms that the provider gets the full amount, then the full amount is consideration for the supply of the worker. The only thing about Adecco did not concern employees, but that's because paragraph 6 of the decision in Adecco confirms that it was common ground that any employees that were seconded by Adecco would be supplies of staff.
Just look at Article 132B. The exemption is for the following transaction, and the transaction is hospital and medical care by hospitals. So I just don't see how that could cover the provision of services to hospitals.
But I was thinking more of item 1, or that.
I think we're agreed, aren't we, that it's the same? Item 1 is C.
Item 1C, yes. So, but I don't see why the provision of medical care and the exercise of medical and paramedical professions might include a nurse who was providing care services, her own nursing services to the hospital. But that would be a different case from main pay, which is providing a range of, as Reed was, a different kind of business. Main pay is, and providing a useful, different kind of business, because by having an employee that you supply, you are taking all the risks of PAYE and NIC away from the customer or the recruitment agency, and it's assumed by main pay or by Mercy. So that's an overall service. What the customer gets is an employed nurse.
Because I have difficulty with how provision of medical care in a hospital can be construed as meaning provision of medical services to the hospital. Surely that means provision of medical care to effectively patients in a hospital.
In 1B, yes, that is certainly the primary meaning of 1B.
No, in 4.
4, which is, that is true. So 4 is the implementation of 1321B. And I would agree that reading 1321B and 4, one is looking at the concept of the activities that are taking in hospital care. It's the care by the hospital. But my point was item 1 could be wider.
Right. Thank you.
Yes, I mean, so perhaps not so obvious as I put to Mr. Venables, and he agreed that 1 and 4 overlap. I'm not sure they do.
No, they are. Certainly from the case law of the Court of Justice, it says they're intended to work in different parameters.
So I mean, the most obvious thing, example of 4 would be where the hospital carries out treatment in circumstances where a patient or an insurance company has to pay for it, and the hospital provides a bill, and that is exempt. Whereas 1 is wider or different, as you say. 1 is where the medical professional, not being an employee, charges, this is the paradigm, and you would say the only case, charges for the supply of his services, or possibly in certain circumstances a company in whom their services are vested, so to speak.
Yes, and
Yeah. Okay. Sorry, that's been helpful to me. I hadn't. It's pretty obvious when you said, but I hadn't quite sorted out the relationship between the two.
and it has developed over time. In the early days, the case law seemed quite narrow, saying that these covered services conducted in the consulting room of the doctor. That's been widened out. It's not simply in the consulting room. It's in the exercise of private practice outside hospitals.
Well, but it would also supply, wouldn't it? It would also apply inside a hospital. If a consultant works in a hospital on a self-employed model and bills the hospital for the work he's done, so it's an NHS hospital, a public hospital, which isn't therefore themselves charging the patient.
Yeah.
At any rate, where so the hospital has put the consultant puts in his bill for performing the list on Wednesday afternoon. He is supplying medical services to the hospital.
Yeah.
And those are exempt as well.
Yeah.
Am I getting it wrong?
No.
Sorry, it's just very...
No, absolutely not. There may be a small amount of overlap in that case about whether the person also falls within hospital care, but that's never been tested. But the key criteria for all of this is that in order to come within the exemption, what the person is supplying has to be properly described as medical care.
Yeah, but what this debate also illustrates is why it is that in main pay, at any rate by the time it got to the Court of Appeal, the focus was all on Article 1321C, not B, and correspondingly item 1, not item 4.
Indeed. But my learned friend says, well, I'm going to run item 4 now, but the answer in main pay to item 1 is the same answer that must apply to item 4 if it's a supply of staff cannot be a supply of the provision.
I think what Lord Justice Phillips was putting to you, and I think you were agreeing with, is that in this respect, B is narrower than C, not wider.
Yes, that's it, narrower in the sense that it is covering a only in hospitals.
Yes.
Situation only in hospitals. But they are different roles, but they provide different roles, and they are enacted into separate provisions of the UK domestic provision. And some of my learned friends' submissions was looking at item 4 and then saying, well, it's wider than 1321C. But that's comparing the
We
wrong
start to
thing.
get onto a sort of slight sliding scale then, do we? Because the doctor providing his services to the hospital is providing medical services. But if he sets up a company and provides his services through a company, is he still providing the medical services, or is the company providing staff? And then if a group of doctors set up a company to provide, to administer their practices collectively, and they call themselves Harley Street Limited, is that company providing services, or is it providing staff?
Yeah.
If then an agency, if then a company has a whole batch of doctors which it provides on an ad hoc basis, is it providing medical services, or is it providing staff?
Yes, I agree, totally agree. There is a sliding scale.
And once one gets to that point, it's quite difficult to see where you draw the line.
There is a line to be drawn, but my learned friend's cases, there isn't a line. He says that if you provide
A doctor.
a doctor,
providing
you are
medical
providing the services. So he says there's no line. All the other cases say that yes, there is. You've got to look.
And that's where control and supervision come in.
Control and supervision
Yeah.
are to be taken into account, and there is no challenge to the facts on the basis on which the Mr. Justice Richards took his decision. There's no suggestion that the facts here are materially different to the facts in main pay.
Yeah.
My learned friend is putting a very bold proposition of law that in every case where a staff is provided, then that the services which those staff will perform are supplied by the person that's providing the staff, and that is what main pay says is wrong.
Maybe, maybe not. You could quibble with how the line was drawn. In all line drawing exercises, there may be arguments to be had. But at this stage of the argument, we're saying, well, main pay's decided that for us.
Yeah, and
Subject to the manifest error point, end of story.
indeed. That's subject to the assumption point and
Subject to the assumption point and the yes, and the manifest
But
error
I think the
point.
assumption point really has fallen away because my learned friend was not able to show you any meaningful discrepancy between EU law and UK law on which his assumption arose. And in any event, it is absolutely clear from the decision in main pay that this was not an assumption. This was the issue that was decided in main pay. Lady Justice Whipple explained why it was relevant, because it that was the way that the first tier tribunal had approached it and the upper tribunal approached it. So it was, and she had to ask herself, was that conceptually right? And she said, yes, that was a conceptually appropriate approach to take. And then she went to look at the authorities of Reed and Adecco and Horizon, which the same distinction had been recognised, and her interpretation, the court's interpretation of those authorities and the legislation was produced the proposition of law which they came to. So there is no possibility of saying that this was a case where there's been an assumption, like in the Kadim case, where you may recall the earlier case of Goonery had there was a provision in which the Court of Appeal had just assumed that if Mr. Goonery had shared a kitchen with his landlord, so that was the only reasoning, so that he was treated as residing with the landlord. That was the two words. But here we have paragraphs of judgment analysing the position, considering it, and coming to a decision on it. So one then asks, well, is that part of the ratio? Yes. Has the court considered it? Yes. And that leaves one with the question, does it fall within is it per incuria?
Well, we'll come to per incuriam in a moment. Just on the assumption point, I Kadim point, in other words. I mean, you framed it as I would expect by saying, here is the proposition, which is the binding problem, which is the ratio proposition. That proposition was clearly fully considered. See Paris 51 to 57. End of story. I think what what Mr. Venables says is, no, you've got to break it down a bit. If there were available arguments that fed into the support, which were relevant to that proposition, which were not developed or not produced, that in itself is capable of being an assumption. There is an assumption that ... In this case, the assumption put forward is that the scope of the EU and the domestic exemptions were the same. And you said that he didn't make that good. That, if you're right about that, end of story. If you're not right about that, have you got anything to add on the question of how you decide at what point a sub-issue or a supporting argument could be treated as, in itself, an issue that wasn't looked at? Do you follow me?
Yeah.
I think where Mr. Venables came out, and speaking for myself, where I think I am as well, is that you probably can't find a nice simple touchstone that would distinguish between the one and the other. But if you can supply one, now's your chance.
But I would say that if one does start with the identifying what is the proposition of law that has been decided, then the rules of per incuriam do come into play on that.
Well, do you mean per incuriam or do you mean Kadim?
Subject to Kadim, then...
Yes, but I'm not talking, sorry, perhaps we're at cross purposes. The moment I'm putting per incuriam to one side, and I'm just talking about the separate rule in Kadim, which is a rule about assumptions.
Yes.
And the question is, can you characterize it as an assumption where, although the proposition itself was clearly considered, an important argument that might have affected the outcome was not considered at all? I'm making myself clear.
Yeah, but what I would say to that is that if you look at what Kadim says on look at tab 12 of the authorities bundle.
Yeah.
I'd say you do have to look at the proposition of law that is decided.
Well, it doesn't. Yes, I mean that he talks about, or they, so I think the judgment of the court, talk about issues. That's actually the key phrase they use.
The principle in 33 is that the court is not bound by a proposition of law assumed by an earlier
Yes, I see.
court
Yes,
that was not the subject of argument before or consideration by that court. So, in the present case, one asks oneself, identified the proposition of law that we rely on, was that the subject of argument or consideration by that court? We would say both. My own friend tries to say it wasn't the subject of argument because the argument was all about control, as if that was a completely different argument, but the control argument was just a facet of the basic question as to whether there is a distinction between a supply of services and a supply of supply of staff and a supply of the services which the staff perform. But in the present case, the issue that the proposition of law that the court came up with was, even if not argued, was
well, you're right. He does use the
consideration.
language of proposition, though they also do talk about issues. The whole think it's headed the rule as to issues assumed without argument, and some of the case law which they build on also talks about issues rather than propositions.
I would say once the court has applied its mind to deciding the proposition which it does decide,
Yeah.
then the fact that there is another issue that could have been raised as an argument falls within the Morel type of.
It's then per curiam or nothing. Yes, okay. Well, that's fair enough. Thank you. Is that all you want to say about the Kadim aspect?
That's really what I wanted to say about the Kadim aspect, and in doing that, I've come close to saying all I want to say about the manifest error of law aspect, because in my submission, if one looks at how that proposition was put in Morel, and Morel was cited in Kadim as an example of an authority where the narrowness of the per incuriam rule was emphasised. And in my submission, the Court of Appeal here is taking care to show the limitations of departing from the rule of per incuriam. I don't know if you have the
Yes.
case of Morel that was handed up.
Yes.
Because on page 406 that we looked at, the court reaffirms that the general rule that the only cases in which decisions should be held to have been given per incuriam are those decisions given in ignorance or forgetfulness of some inconsistent statutory provision or of some authority binding on the court concerned, so that in such cases some part of the decision or some step in the reasoning on which it is based is found on that account to be demonstrably wrong. So this is really just setting out the traditional per incuriam.
Yeah.
This is the kind of thing that needs to happen before it can be said that the decision is demonstrably wrong.
To the status of a decision. Let's take the example of a Privy Council decision, which is wrongly treated by the earlier Court of Appeal as if it were English authority, and thus binding upon it, when in fact, of course, as we all know, Privy Council decisions are not binding. What about that?
So the Court of Appeal has decided,
has treated the Privy Council decision as being binding upon it. So it's not that it's ignored it or forgotten about it. On the contrary, it's expressly relied upon it, but treated it as binding when in fact it's not binding.
You can make the case as stark as possible by saying that it was faced with another authority of the Court of Appeal saying A, by which it would normally be banned, but by a decision of the Privy Council saying B. And it says, well, normally we'd be bound by A. Perhaps we would agree with it, but the Privy Council has said B. That doesn't fall within the first couple of sentences of the first full para on 406. But it may be, I'm sorry, I'm thinking aloud and perhaps springing my Lord's trap. That might be the sort of point they had in mind, where they built in the third sentence, which says this definition is not necessarily exhaustive.
yes,
I mean,
and also say, but they say there could be rare rare and exceptional cases
Yeah.
in which it could properly be held to be per incuriam on other grounds. But they then say they cannot regard this as such a case. And then when they turn on to the part my learned friend says, they say that it's impossible to fasten upon any part of the decision under consideration or upon any step in the reasoning upon which the judgments were based, and so that here was a manifest slip or error. So one's looking at step by step. Is there a manifest slip or error such as already been identified?
Can we just go? I mean, I'll come clean with you. I'm not really that troubled by this argument in this context, but I still do want to understand exactly what they're saying in this paragraph in Morel. They start by what, in the first full sentence, the long sentence starting as a general rule, by setting out what we normally understand by per incuriam, i.e. overlooking a statute or binding authority. So that's the great majority of cases. But they immediately say this definition is not necessarily exhaustive. So they're saying you can be per incuriam in other rare cases. And that's all they say in the next sentence. And again, they make that clear where they talk about, in the following sentence, they say this wasn't a case of ordinary per incuriam, and again repeating there could be cases that are not ordinary per incuriam but are still per incuriam. This isn't such a case. Fascinating. Why not? Then go to the next sentence. Because, you might say, it's impossible to fasten on any part of the decision under consideration or any step in the reasoning where we say here is a manifest slip or error. Now, Mr. Venables, as a matter simply of construing this passage, is entitled to say that the reference to manifest slip or error is really the test of that third exceptional class of per incuriam. Is that a fair way of reading it?
It reads to me more like they, having dismissed this case as being not one of the rare exceptional cases, that sentence in the middle, then they go on to explain why.
Yes, well, that's what I'm saying. But it's quite interesting, the reason they give for it being not one of the rare exceptional cases is that this isn't a case where there's a manifest slip or error.
Well, he may be coming back there to say, well, what is the difference? Because they are essentially applying the step-by-step approach, which they have previously explained as being the ordinary per incuriam. You've just got to look at it step by step, so that there's some step in the reasoning which is based or found to be demonstrably wrong. But
the example my Lord's devised seems to me may not strictly come within the first wording, but it is ignoring a binding authority, the Court of Appeal authority, and it is regarding an authority as binding which isn't binding. One could say that there are manifest slips or error which are not perhaps strictly within the rubric but are very close to it.
Yeah.
maybe.
I think, speaking for myself, I agree. I think shows they were wise not to tie it entirely to the standard thing of per incuriam. But they don't. The only test of the exceptional class of per incuriam they give is manifest slip or error. But I think we're entitled to read from what they go on that they mean that in a very narrow sense. But beyond that, we don't get much guidance.
No. The sort of manifest slip or error. I mean, slip does very much suggest that the court has just not taken account of something which is fundamental to the decision which it obviously should have done, such as...
Yeah, but if you just put it that way, as a risk you open the door too wide.
Because I'm saying that they are reading it in the same way as their per incuriam analysis. That is the step by step analysis.
I think what you say is it's perhaps the best way to put it is it's something akin to overlooking a binding statute or authority, even if it's not strictly that.
Manifest step is something that can be seen on the face
Put on a word on the word manifest, perhaps.
But doesn't it go on to say it's so that some part of the decision or step on which it is based on that account to be demonstrably wrong? And that is the rationale for it has to be a manifest slip or error, which shows that the decision or step in it is demonstrably wrong.
Yes.
It's
And where a court has looked at the right, has not disregarded a case, and has not disregarded a provision, has considered them, that will not be such a rare and exceptional case.
Yes, well, thank you. Anything else on manifest slip or error?
I would be grateful if you could assist us with the distinction that, or the two different types of distinction that Mr. Venables was praying against as part of his argument. And he was arguing that the distinction that was being drawn in Reed was different to the distinction that was being relied upon in main pay, and that therefore there was a misunderstanding by the court in that case, in the main pay case. Can you assist us with that?
Yes, I'll just. I think it might be helpful to look at his skeleton argument where he sets out exactly what the distinction is. It's paragraph 41 of his skeleton, page 219 of the bundle. So he says that in Reed, there was looking at merely effecting an introduction of staff without participating in the chain of supply and supplying the services of workers by taking part in the chain of supply. So we would say, first of all, that that's not a relevant distinction. I mean, effecting an introduction of staff without participating in the chain of supply is not right. If you provide staff, you do participate in the chain of supply. Reed or main pay are making a charge to their customer, and in the present case, so the umbrella company makes a charge for its services to the recruitment agency and charges VAT on that supply. The recruitment agency makes an onward supply of staff to whoever and makes charges VAT on that supply, and so the recruitment agency sets off the tax it's been charged by the umbrella company against the onward supply it makes. So it is participating in the chain of supply, and so whether you describe something as merely effecting an introduction of staff or supplying of the services of the workers who are actually performing services is just a different way of framing the question that arises in this case or in main pay. Have we got something that is simply a supply of the staff, whether you call that an introduction or a secondment, whatever it is something that is performed by the introducer or the seconder by making the staff available, and the question is whether the supply looked at in the round that main pay or Mercy carries out is a supply of staff, or whether the situation is different, and so that what Mercy is contracted to provide is medical services. So we say that the distinction raised in Reed is the same distinction as the distinction raised in the present case. And the other distinction that my learned friend puts forward at 41 is essentially a man of straw, because he says that the distinction is two different types of supply of staff. But the issue in this case is whether you can properly characterise what the supplier is doing as a supply of services of a type that can fall within the scope of an exemption, or whether it falls short of that because it's simply the provision of the staff to enable those staff to carry on the activities as part of the activities of eventually the NHS Trust. But as far as Mercy and Mayfair are concerned, they're just making a provision of staff onward to the recruitment agencies. And except there may be cases where it's difficult. There may be cases where you've got to look carefully at the facts. But what there isn't is an absolute fundamental proposition of law which the Act relies upon that says that distinction doesn't exist.
Thank you.
Any other points you wish to make?
I think then on Reed, as the learned friend made it quite well, in Reed it was different because Reed was only charged its commission, and that's what the argument was about. And I think I completely accept that it doesn't sell on the face of the judgment, but it seems clear that Reed was charging its commission. The business model that Reed had was that there was no contract of employment with the nurses, and there was no contract at all, as far as we can say, between the nurses and the hospitals. So the nurses were provided to the hospitals. There was no contract between those, but the hospitals paid the nurses' remuneration to Reed, who just paid them on. It wasn't part of any consideration of the supply by Reed. The thing that Reed was doing was agreeing separate consideration by its commission to provide its service. Now that's different as a business model from the Adecco or the present model, where a person is provided. In Adecco, it was a self-employed person that was talked about, but in the present case, it's an employee. For a single fee, no one is suggesting in the present case that it's appropriate to break down the fee in the present case or apportion it in some way. My learned friend accepts that if it doesn't fall within the scope of medical exemptions, then the whole fee is subject to VAT. So the fact that in Reed only made a charge for its commission, and the fact that an umbrella company makes a single charge to its customer for the whole amount is just a feature of the different business model of a secondment. I mean, having a secondment entails introducing a charge, a VAT charge, where one otherwise would not exist. Because if you had an employee of company A, and the employment of that employee is transferred to company B, then his salary is outside the scope of tax, whether he works for company A, and his salary is outside the scope when he works for company B. But if instead there is a secondment of that employee from one company to the other, and company B pays for the secondment, then that is a supply of services. It's not and the reason why it's a supply is because that employee has ceased to be an employee. the employee is always the employment money, the remuneration paid to the employee is always outside the scope of that. But what you've done is introduce a service. You've done something else for consideration, so that's why it's chargeable to tax. And the question is that all that's happened, or have you actually agreed to provide some other service that's like a medical exemption? And so although we accept that in the Horizon case, the scope of the educational exemption was different, the point that Lady Justice Whipple took from Horizon was that the Advocate General had used this concept, well, it's a supply of staff rather than a supply of educational services. So conceptually, it's an appropriate way to look at it. My Lord, unless I have any matters that I will assist you with.
Thank you very much indeed, Mr. Baldwin. Anything you want to say by way of reply, Mr. Venables?
If I might, Peter, my lord, I appreciate it's late. I won't take long. If I could firstly take one of the last points my learned friend made concerning, it was asked by my Lord Justice Arnold about the distinction in Reed and Adegbuyi on the one hand, and the distinction in main pay. And he referred to paragraph 41 of my skeleton, where we say that there's a difference. That what Reed and Adegbuyi were concerned with was whether or not the taxpayer was, the language I used was effecting an introduction without participating in the chain of supply. Now, by that, I meant without contractually participating in the chain of supply. i.e., no agreement by the taxpayer to provide the services of any particular person or to second any particular person. That's the crucial distinction. If I could pick up a point, the other point is one made by my Lord Justice Phillips, which is the question as to the scope of the exemptions. And you asked, would, say, a self-employed nurse providing her services to a hospital, being paid for it, make an exempt supply? And my learned friend said, yes. And I think that must be right. And this, I think, and then you said, well, I suppose it's through a company. Well, I think we know from Kugler that doesn't make any difference. And then you said, I suppose there was a company, as one might well find in Harley Street, where you have a group of doctors. Again, it shouldn't make a difference. And the extraordinary thing about this situation is that if, but my learned friend clearly accepts it, it's said that simply because you have an umbrella company with lots of employees who then seconds their services to the hospital, as opposed to, say, a smaller company or an in-house company, a one-doctor company, a several-doctor company, that makes a world of difference. And hey presto, you've created a charge to VAT out of thin air, which would be rather surprising, because at the end of the day, you would expect the medical exemption to apply. Now this, admittedly, doesn't go to strict point that you asked me to comment on as to the binding authority of main pay, but it does make one wonder whether that decision can be right. It might be seriously wrong.
But you're not supplying the workers, to use a broad term, to the hospitals. You're supplying them to a recruitment agency.
Yes, I agree. It's a slightly more complex situation, but in principle, that shouldn't make any difference. What you're doing is you're seconding the You're seconding the employees to the recruitment agency, and the recruitment agency is then subseconding them to the hospital. I'm told that this is done for commercial reasons because it's the recruitment agencies who insist on this. They want to make sure they're not cut out of the action and that they know what's happening. But in every case, it is quite clear what the services are which are going to be performed. And I should make absolutely clear, of course, it's our case that the exemption applies to companies like Mainpena and Mercy is limited to the case where it is known that the only services which will be performed will be services of the appropriate description, medical, nursing, whatever. Yes.
But they're going to the medical staff will supply medical services to the hospital, but they won't be supplying them to the recruitment agency.
I'm sorry, well, I didn't...
They won't be supplying them to the recruitment agency.
No, they wouldn't. No, not normally. It's but the fact that the recruitment agency is put there in the middle. Now, unfortunately, there is not a decision of the courts, but a decision of the tribunal, either the lower Arthur tribunal, which says that this actually makes no difference at the end of the day, whether it goes straight to the hospital or straight through or goes through the intermediary of the recruitment agency. I'm sorry I don't have that readily to hand.
We'll rise for a few minutes.
Court rise if able.
Thank you for having helped with note 2 to item 1. I thought that showed how barristers should properly behave. I knew it and I'd forgotten it.
Yes.
There are so many.
I think you mentioned it somewhere.
Oh, well, yes, of course. It's all there in the previous advice. You've got so many points and so many things we prepared for, and so many more things we haven't prepared for.
Yes.
Court rise if able.
Mr. Venables, we are not persuaded by grounds 1 and 2. In those circumstances, we don't need to hear argument on ground 3, and we would propose simply to dismiss the appeal. Reasons will follow, but it makes sense at this stage. I don't think you need to see the reasons in order to deal with any consequential issues. Are there any consequential orders that either party wishes for?
May I just ask your Lordship's elucidation on one point? We would apply for permission to take this to the Supreme Court.
Yes, I thought you might.
It may be a foregone conclusion, really, on the authorities that your Lordships would feel bound to refuse it and leave the decision to the Supreme Court. But I just want to make sure that if I don't make that now, I won't be out of time to make it later.
I don't think we're formally out of time, but I don't see any advantage in your putting it off. In a issue of this kind, you don't need to have seen I wouldn't have thought to have seen the details of our reasoning. You know what the issues are, and you know why you say you're right. There may be very exceptional cases where, for some particular reason, you can't decide whether to make an application for permission until you've seen the reasons. that's really the case, I suppose we'll wait and you can make the submissions on paper after you've seen the reasons. I don't think we'll insist, but it just seemed more efficient and realistic to make the application now. I'm being reminded by my lord that although there's no time limit at this level for you to make the application to us, there is a time limit for the application to the Supreme Court,
And we can't extend it.
which we can't extend. I think I may have been a little hasty in trying to persuade you to make the application now. I can see why, if you're making an application to the Supreme Court, you would like to see our reasons. And that, well,
The application to us can still be made now.
And left undetermined.
No, we could give you an answer.
Right.
yes, I'm sorry, my lord is ahead of me. It's in fact in your interest to make the application now. Otherwise, you'll have to ask the Supreme Court for an extension, which I admit you'd almost certainly get if you said you were waiting for the reasons. But why not cross that off, tick that off your box now? Let's just hear if any other applications. Well, you can think about your position while we hear about that.
Well, my lord, the only application I would have is an application for costs.
Yes, well,
Maybe we could do that in the agreed order,
Yes, well,
given the time.
but it's not a case where there needs to be a summary assessment because it's down for more than one day, or whether you say you can do it in the agreed order, certainly, but I mean, you need to know what we would say if you made the application, so you better make it.
Well, in which case I make an application for the costs.
You can't resist that, can you, Mr. Venables?
I can't indeed.
No, very well. The appeal will be dismissed with costs. Do you wish to make your application, having thought about it for 30 seconds, to appeal to the
Yes.
Supreme Court now?
Could I just take... There is
Yes,
a
of course,
point.
take a moment.
There may be a point on costs, which if I could just liaise
Oh, I
with
see.
my learned you. No, my lord, there's nothing further on costs, but if I could formally make the application for the commission.
I think that makes sense. You don't need to develop it. You rely on all the arguments which we have rejected, but you nevertheless say that they are arguable and important and deserve the, as you would accept, exceptional course of arguing permission rather than the Supreme Court. Yes. Permission to appeal to the Supreme Court is refused.
My lord, it's not an application as such, but it was, your lordship to be aware, this is an expedited hearing that's come before you. There is a trial of the underlying issue set down for November, and of course it would be extremely useful to have your lordship's guidance on this.
Well, I think it's in everyone's interests that we get our decision out as soon as we can. Anyway, I'm not quite sure surely if you refuse permission to amend, that's all, we'll be possibly anxious not to say anything, and I can't quite see what we would say that would actually bear on the remaining issues. So from that point of view, I'm not sure you particularly need to see our reasons in advance of the hearing, though I would hope that you would.
I'm grateful.
My lord, the learned junior suggested I make a point. I'm not sure whether or not it's appropriate to make it to this court, which is if the Supreme Court did give us leave to appeal, and then, of course, and it would be a very different argument, obviously, than
Yes.
before this court, and then did allow us to indeed amend so as to introduce the VAT defence. This would mean that the trial, which is scheduled to go ahead in November, would have been conducted on an entirely false basis.
Yes.
I'm not sure that this is anything
Well, I think your instinct is right. I don't see what we can do about that. I mean, just thinking aloud, and this should not be taken as authority because I haven't thought it through. In the first instance, you will want to get on with applying to the Supreme Court. You will, I suspect, need the reasons for that. I say we'll do them as quickly as possible. If the Supreme Court are persuaded to make a decision very quickly and in your favour, then you may have a pretty strong argument to go to the judge and say put it off. If the Supreme Court haven't reached a decision, you will have an argument, on which I express no views at all, that it should be put off anyway in case you get permission. But it's nothing to do with us. That will be for the trial judge, or at any rate the judge in charge of the Chancery lists, or to whom the application is made, to decide whether the possibility that the whole thing will be rendered unnecessary by the decision of the Supreme Court by the possibility that it will be heard by the Supreme Court is sufficient. But that's nothing to do with us, I'm afraid.
My Lord,
Sorry, I just want to check whether either of my lords want to add anything to that.
may I just check my learned junior that I've correctly... Lords, that's entirely understood. Thank you for that.
Yes. Very well. Well, thank you both for your helpful arguments, and to those behind you who I'm sure have contributed a good deal to their development. Nothing more to say.
Court rise if able.
Well done.